morning, everyone. First on the docket is AG number 11, and that is Attorney Grievance Commission versus Maldonado.
If I may, I'll switch from the podium to the table, if I may. It's kind of heavy, the notebooks.
Well, what we'll want you to do is, as much as you can, is stay by the podium.
Okay.
But of course, if you're addressing us, that's where you want to be, because we hear you better through
Okay,
this if you're at the podium.
All right, thank you.
ma'am.
Yes, thank you.
You can certainly feel free to retrieve.
Okay.
And bring, I understand.
Good morning, Your Honors. And I want to thank you very much for taking time out to review my file. And as you can tell, I'm detail-oriented, so I appreciate it, because I know you have a very busy docket. And thank you so much. And I'd like to start out on this day before Election Day to say that I do believe that this was a political hit against me. I'll focus on the evidence and the facts, of course, by hundreds of the evidence, but I'll get into that a little bit, and I'll try to simplify and cut to the chase. One of my favorite judges was the Honorable Howard Chasnow, who served on this court from 1990 to 1999. And I want to let you know that he told me when I saved a little girl who was 4 years old. She was in a coma from toxic mold and severe water damage, and this was in 2016. And I rescued the case from 3 super lawyer law firms in Maryland. And he told me, he said, "Melinda, only you could have saved her and her mother. The statute was running out, and I went in with my background, my educational background, and I saved her." And the defense lawyers were even drawn to tears. I was very respectful and professional with them. And in fact, after that case, the Courtney Edwards case, 2 of the defense lawyers quit the defense side. That's how much it impacted them. So with that, I want to go ahead and segue in. And I'd like to say the reason, by preponderance of the evidence, that this seems like a hit against me, just like the AGC versus Alan Dyer and Susan Gray case that I cited, this wasn't by a client that filed this complaint, that filed this grievance. This was by opposing counsel, the opposing defense firm representing the real estate industry, James Liskow, and he works for Jeffrey DeCaro, and Jeffrey DeCaro was on the Grievance Commission, and I believe it was 10 years. So to me, it was just like, what's going on? And they made all these false allegations against me, but what the evidence shows is, while they started attacking me in 2015, 16, 17, 18 to the present day, and every year since then, 2015, 2016, 2017, 2018, I keep getting nominated to the nation's top 1% in the nation. And this is by Judicial Review Board. And they don't even say who the judges are for confidentiality and impartiality. They don't want any bias, anything. So these are judges that are looking at my case results. And at this time, my win record was 100%, 17 wins, 0 losses. And I will say, with all due respect, it is in my humble opinion that toxic mold litigation is the most complex litigation there is. It's much harder than asbestos. And I see that you guys are taking a look at asbestos and about the statute of limitations for that. And I want to let you know this is even a much higher level. So with that, I just want to say it just doesn't add up. They're saying I'm incompetent. They're saying I'm this and that. And I keep getting these top 1%. And I believe approximately 1 to 2% are women. I think it might be a little bit higher, but not a lot. Okay, so for 3 years, we'll go to, I know you guys like to refer to what the judge said. Judge Dwyer. And what I want to say is, as you notice, I'm representing myself. I had Bill Brennan, but they didn't put any exhibits in. They only put like 2, and a third one, the medical record at issue, because I happened to have it in my possession that morning. And I had emailed them in plenty of time, all the exhibits. And you guys, your honors, have my exhibits now. So I'm representing myself, as you can see, and that's a huge factor here, because Judge Dwyer says in the beginning of her opinion, based on the evidence submitted, and Bill Brennan didn't put any in. And you saw him Friday, he had 2 cases. So, there's a lot going on. So with all due respect, I want to thank you for looking at my exhibits. And I'll go into these allegations. First of all, competence. That doesn't apply here. That's a false allegation. 17-0 win record, nation's top 1%. They argued about the trial transcript. Well, this case, by the preponderance of the evidence, the real estate companies, Home Properties, Home Property Co. Townhome, that rented 2 townhomes to this lady. And by the way, before I'm through, I will show you her picture as well. You can see her left eye is almost shut. She's losing her vision. She's African American, and her name's Gladys Duran. She was named after Gladys Knight in the Pips. And this wonderful lady could sing Etta James At Last better than Etta James before this happened. She could have been a star. She is a star anyway, for all her strength. So they took her voice away, but they're not going to take her dignity. And I'm the only lawyer in this situation that fought for her. So the first charge, competence, no way. No way.
Well, the court, if I have it correct, the court found to violate, in its conclusion of law, the court determined that your failure to order transcripts when the case was pending in the Court of Special Appeals.
Yeah, that's not true. That's false, because I had the 3rd day, and because of all the shenanigans that James Liskow did with this false complaint, and I'll get into the doctor thing, but I was able to get her. Chris Nace withdrew, and the withdrawal was granted on October 21, 2015, 3 months into the appeal. He abandoned this client. You don't abandon the client. He didn't get my permission. I mean, there's no certified mail. There's no tracking number. He abandoned the client. And why did he abandon the client? Because James Liskow, who filed this grievance, he threatened him. And I caught them in a lie. If you look at Exhibit P, page 3, line 3 from the bottom, he said it's going to get worse. This was at trial. Things are going to get worse. And James Liskow said, oh, no, in the hearing, I have the citation. He goes, no, I didn't threaten him. And Chris Nace said, oh, he didn't threaten me. And in fact, I have an exhibit. There's an email dated November 29, 2016, when I'm trying to get to the bottom of it. What happened? And he said, oh, I don't know why you believe that James Liskow told me about the grievance against you before I filed the motion to withdraw. They're conflicting right there. So he's lying to me, and he abandoned the client. Chris Nace abandoned the client. So back to the trial transcript. I ordered the 3rd day because I briefed Attorney General Brian Frosch, his former law partner, Lee Norwent, when we were evaluating this. So that left days 1 and 2. I was able, on December 17th, on December 8th, I brought Gladys Duran, who's disabled from this by preponderance of the evidence, I brought her over to the Court of Special Appeals clerk. 769 pages of med records. I held her by her arm. The security guard let us park right by where you guys normally park before this construction, right out here. And I held her by her arm. I drove from Arlington, Virginia, came over here, guided her. We put it in, and Chief Judge Peter Krauser granted it. He gave her 7 weeks on December 17th. And here's the key fact of all. He gave her almost 2 more months to get a new Maryland lawyer. And I don't think you should have let Chris Nace out. I really think that's really, but almost 2 more months to get a new lawyer and to get day 1 and 2 of the transcript. Well, I'm not here. I'm in Austin, Texas, because my mother was diagnosed with stage 4 cancer. She was diagnosed. I took her to get a biopsy on December 18th. December 22nd, she's diagnosed. So I'm pulling all-nighters in MD Anderson and riding in an ambulance for 3 hours. That's what I'm doing. But Gladys called. She said, she said, this is a success. You got me 2 more. She said, I've got 2 more months. So I told her husband, I told Gladys. And so it was, with all due respect, it was up to them to get day 1 and 2 and to try to find a Maryland lawyer. But because this litigation is so complex and it's 3 months into appeal, it was tough. But I they're on the, I'm not on e-file. Because when Chris Nace pulled out, I'm not on e-file. But I'm very proud that she had 2 more months at least. So with the trial transcript, it was in their hands to get day 1 and 2. And the petitioner never brought this up. And Judge Dwyer's committing clear error here when I'm gone and I'm away and I'm not even the lawyer. So I went above and beyond for her with that. So I just wanted to say that that's a very key fact, and I believe in this lady. So that's my response to that. So do I have 5 minutes? I think?
Mm-hmm.
Okay, thank you, ma'am. Thank you, Your Honor.
Yes.
So that's a critical issue there. And then the Rule 4.1, truthfulness in statement to others. This is why I received this for the last 4 years, because of my character and integrity. One thing that I'll say is 1 week before this hearing, so there's no evidence, my lawyers don't put evidence in, 1 week before the hearing, a pipe explodes outside my office door. 1 week before the hearing. It's a 3-foot flood, my files get destroyed. And before that, a black shirt was hanging on my front door for 3 weeks in the summer of 2017. And I have, by preponderance of the evidence, I have proof that it was the petitioner. And they trespassed as well in the summer of 2017.
When you say the petitioner, you mean bar counsel?
Yes, an agent of the bar council. So so I just wanted you to know, not only am I getting defamed about saying I'm a doctor, the exhibits show I said lawyer, and about changing the med records, the exhibits show mold exposure 3 years. It's right there. It's gross negligence by all the parties and Judge Dwyer. The medical record shows allergic to penicillin. And if you look at page 48, Exhibit E, penicillin is significantly abundant in the townhome. Exhibit E is very critical. Page 47, mold exposure. She's allergic to penicillin at the bottom of page 47. Exhibit E, page 48, it shows significantly abundant. So it gives the dosage and it tells what mold's in there. So the direct causal connection, there was no need to change anything. What happened here is James Liskow, the defense, they didn't understand. Well, they knew they made her sick. They're just trying to throw this as a tactic to get away and not take accountability for her. Because I've never seen such a clear connection in any case I've ever had. And I've never seen, this is about the sickest client I've ever seen. And when I called that doctor's office, I said client. I didn't say patient. So I'll also say that. And if I have another minute, do I have another minute?
Well, I don't know that I've seen the red light, but you can dip into your rebuttal time because you have reserved 15 minutes.
Okay, sure.
We'll be keeping count.
So yes, so I just want to say I'm highly offended by all the parties, by James Liskow, the defense. They try all tactics. They get experts to lie and say, oh, you need to know the dosage level, like in the Chesson case. He actually defrauds and deceives jurists. You don't need to know the dosage level. There's no standard by the EPA. What you need to know is what kind of mold is in there. And you need to know, are they allergic to that kind of mold? And you have that by preponderance of the evidence in this case. And all organ systems shut down, not just the lungs, the heart. Tachycardia starts beating because it's trying to pump out the toxins. So it's heart, lungs, brain, your whole system shuts down. And you'll see her medical records by preponderance of the evidence. And the little girl, the case I won with Howard Chasnow, 4 years old, she almost died. Nanosecond, ambulance had to speed up to make it to save her.
You mentioned earlier that you might comment on the allegation that you made of false representation, referring to yourself as a doctor. Do you want to comment on that?
Oh, sure. Yes, thank you, Your Honor, for the question. I did not ever say physician. I did say Dr. Melinda Maldonado per the Rule 7.1 in Maryland and the ABA rule. There's 2-102 that you can give your educational title as long as you clarify what role you're serving, and I did. Every staff member, you'll see the log. Every staff member said lawyer, environmental attorney, toxic tort legal specialist. And you know what? I'm not ever going to use it again. I'll tell you what. And I even said in my deposition, after the first 2 calls, I didn't say it anymore because I could tell they were a little confused and very rude for sure. But the rules say you can use doctor title per your educational doctor of jurisprudence. And as long as you clarify what role, and I did with every person, even though they were rude. And I was very professional with everyone. I never cussed. I never lost my cool. I was professional. What it was my passion, my zealous passion for my clients. And that's why I get these, because they know I have a big heart, and I use my brain too. So I just want to say I use my brain and my heart in unison, and I fight for everyone. So, and then respect for right of third persons, I was very respectful. I think bottom line, there was confusion on their side, and we had a HIPAA form with the hospital. He was the attending doctor in the hospital, Dr. John Wiley. And the medical records guy said nobody likes him. He's got a God complex. He thinks he's better than everybody, and he's mean. He doesn't respect people. It's just kind of, I'm better than you, that kind of guy. So I would have had him as a witness in the hearing. And then the Rule 5.5, unauthorized practice of law, I'd like to address that, because what this was foul play by the defense firm, as I said, and it was abandonment by Chris Nace, an improper abandonment. And what I'll say, there was no attorney-client contract. There was no money exchanged. What we have is a lady that was severely disabled by preponderance of the evidence from the defense lawyer's clients. So bad. So there's no contract. You got a disabled lady. And she said, Melinda, she couldn't write. She was sick. She was 5 weeks in the hospital, almost dying. And she said, I need an extension of time, Melinda. I need an extension of time. So while everybody abandoned her, I didn't. And I'll say I did it as a human being. And I won't ever be in this situation again, because the peer review panel, they wanted to drop everything, all charges they wanted to drop 2 years ago, right before the presidential election. So every time there's an election, I'm here. But I just wanted to say, they wanted to drop everything. We understand. But they asked me, would you ever do this again? And I'll tell you with all humility and with learning everything that I have, I won't ever be in this situation again, Your Honors, ever. So I won't ever co-counsel with Chris Nace. I've seen more of angles of what the defense lawyers are doing. This is the dirtiest lawyering I've ever seen. And they'll have experts lie, the lawyers lie, and you can see the deposition of Gladys Stern by James Liskow, how he was badgering her. She lost all her hair, 70%, and he blamed her father. Was your father bald? Did your father have male pattern baldness? It was so rude, so rude. So,
Okay, you are into your rebuttal, which
Okay.
is fine, and
Okay.
we'll let you know if you want. It's
Okay.
up to you, you can
Sure.
use.
I'll do rebuttal. Yes,
Okay, very good.
Thank you.
And we'll let you know how much time you have remaining.
Okay, thank you.
When
Thank
you
you.
come to the podium once again. Ms. Lawless.
Good morning. May it please the court, Lydia Lawless on behalf of petitioner. This case involves 2 discrete questions. 1, did the respondent engage in the unauthorized practice of law? And 2, what did the respondent say when she called Dr. Wiley's office repeatedly on July 21st and 22nd, and why did she say it? As to the first question, the answer is yes. Between September 2013 and December 2014, approximately 15 months, the respondent engaged in the unauthorized practice of law in violation of Rule 5.5. During that time, she met with Ms. Dern, consulted with her, advised her on Maryland law, and drafted and caused to be filed a complaint, which was purportedly filed pro se in the Circuit Court for Anne Arundel County, an information report, and subsequently an amended complaint. On each document, the respondent worked to conceal her unauthorized practice of law by drafting the documents and having her client file them pro se. Once she obtained co-counsel and a Maryland sponsor, she was authorized to practice in the Maryland courts. That authorization continued through the pendency of the trial, which was in the summer of 2015. On October 16, 2015, after her Maryland sponsoring attorney withdrew from the appeal then pending before the Court of Special Appeals, the respondent acknowledged in an October 16, 2015 email that she knew she was required to have Maryland counsel to continue in the case. Notwithstanding that acknowledgement, the respondent continued to represent the client for almost 1 year, through September 29, 2016, when Mr. Nace's appearance was struck by the Court of Special Appeals, and the denial of the writ of certiorari, between October 2nd, 2015, when the appearance was struck, and September 29th, 2016, when this court denied ultimately the motion for reconsideration on the petition for writ of certiorari. During that approximate 1 year period of time, the respondent drafted and filed, using her client's email address to file through the MDEX system, numerous papers, including a motion for extension of time, motion for reconsideration of the dismissal of the appeal in the Court of Special Appeals, a petition for writ of certiorari in this court, 2 replies to the answer to the petition, and ultimately a motion for reconsideration when certiorari was denied. As before, in each filing, the respondent attempted to circumvent the clear requirements prohibiting the unauthorized practice of law by representing that the papers were being filed by her client pro se, by using her client's email address, and by physically driving her client to the courthouse to ensure filings were made.
Counsel, is there a line between ghostwriting and what was done in this case?
Well, I think what was done in this case is ghostwriting, and the question is whether or not the ghostwriting is authorized versus unauthorized. And in Maryland State Court, unlike Maryland Federal Court, where ghostwriting is strictly prohibited, this court permits, under Rule 1.2, the scope of limitation and the limited representation, attorneys to ghostwrite pleadings for clients to then file. The caveat is that they must be authorized to practice law in this state. So the question as to ghostwriting, there's no question in my mind that it was ghostwriting, but it was unauthorized. This court found in Attorney Grievance Commission versus Zhang that the respondent attorney in that case, when she drafted and prepared pleadings to be filed by her niece in a Virginia case, that she engaged in the unauthorized practice of law. This court found that Ms. Zhang additionally engaged in the unauthorized practice of law when she participated in settlement negotiations in a Virginia case and prepared for hearings in a Virginia court. Similarly, in Attorney Grievance Commission versus Phillips, this court found that the respondent attorney assisted his son in the unauthorized practice of law. And in that case, the son engaged in the unauthorized practice of law when he sent a cease and dismiss letter or a demand letter to an individual when he was unauthorized to practice. One thing that I think in light of the Lang and Falusi case that was filed in 2018, one thing that I would like to address is the question about whether or not the practice that Ms. Maldonado was engaged in was temporary and whether or not she reasonably expected to be authorized to practice. And I would state to this court that the 2 discrete periods of time where she represented Ms. Duran without authorization, without co-counsel, was not a temporary basis for a case in which she reasonably expected to be admitted pro hoc vice. And what she would have this court do, what the respondent would have this court do, is essentially create an exception that would envelop the entire prohibition against the unauthorized practice of law, to say if I can't find Maryland counsel, or if I have a client that is in need of an attorney, then I can not only represent that client, but continue to represent that client for sustained periods of time without notifying any court that I'm engaged in the representation in any manner.
So what should an attorney do in an instance like this one where the Maryland counsel withdraws from the case?
They should either find new Maryland counsel
If they can, yeah.
or terminate the representation. Those are the only options.
Is there
Your
a
Honor.
time period during which they may continue to assist the client?
Well, if you look at this case, the notice of appeal was filed to preserve the client's appellate's rights in the Circuit Court for Anne Arundel County. And then I think it was within a month, maybe 45 days, once it was transmitted to the Court of Special Appeals, that Mr. Nace moved to withdraw his appearance. I think it was October 1st or so. And so there's this period of time before which any action is required, before which the transcript needs to be ordered, before which a brief needs to be filed, that maybe that's the reasonable time that you can say to the client, I will represent you in the appeal if I can find a Maryland attorney to sponsor me. But once that period of time to perfect the appeal comes and goes, I would state that it is unreasonable, and especially in light of this case and these facts in this case where the respondent said she contacted 20 attorneys and no one would help her with the case, that there was no reasonable expectation that someone was going to come in. And I think the other critical fact for this case is the initial period of time when she was engaged in the unauthorized practice of law. August of 2015, it was the summer of 2013 when she first began to represent the client. According to the respondent, the statute of limitations for filing this lawsuit was April 26, 2016. So there was an extended period of time in which she could have sought to obtain co-counsel. And when she didn't, and when that statute was upon her, she at that point had to make the decision that she could not represent the client moving forward because it was not authorized. And her own testimony, like I said, was that during that initial period of time, before the complaint was originally filed, she consulted with numerous attorneys and no one was willing to serve as a Maryland sponsoring attorney for her.
What is our most recent case? And I have one kind of stuck in my mind, but I don't recall the particulars of it, involving unauthorized practice, where the attorney was essentially ghostwriting and assisting the client.
I don't know if the Zhang case, I think, might be the most recent as it relates to ghostwriting. That was a 2014 case. The Hunt case also involved the unauthorized practice of law. That was a 2016 case. That wasn't a ghostwriting case. That was where the respondent attorney came in and represented a client in one district court hearing. And the Dalton Phillips case, to some extent, involves the issue, it's not as much ghostwriting as just the unauthorized practice of law and assisting someone in the unauthorized practice of law. I think that the Lang and Falusi case of the last term was the most recent unauthorized practice of law case.
Which one was that?
Lang and Falusi
Yes.
in 2018, and the issue that was critical in that case was the question about whether or not Mr. Falusi was associated with Mr. Lang in the representation. So it was a different exception at issue than in this case, where there was no association, and it was beyond a temporary representation. The second question for this court's consideration is the question as to what the respondent said when she called Dr. Wiley's office. I think it was 7 times between July 21st and July 22nd, 2015. That question is a question of fact that turned on the credibility of the witnesses. Judge Dwyer resolved that question, making a credibility finding adverse to the respondent. What Judge Dwyer said was that the respondent made a knowingly false statement of material fact when she identified herself as Dr. Maldonado that she twisted the facts and the truth deliberately to mislead or attempted to mislead others in order to obtain something on behalf of her clients. She was misleading or made misrepresentations and was misleading when she represented repeatedly that she was a doctor and that she went to medical school. Judge Dwyer found the respondent's testimony and explanation that she immediately clarified that she was a lawyer, not to be credible.
Ms. Lawless, refresh on my recollection. Was there a witness or were there witnesses to the contrary, folks who had been on the receiving end of the telephone calls who testified?
Yes, Your Honor. Petitioner called to testify at trial Ms. Lipscomb, I believe her name was, and she was the receptionist or a medical assistant at the doctor's office that answered several of the phone calls. Additionally, there was evidence admitted by way of the telephone notes, the log, the business records associated with the communications, both internally regarding the respondent's communications to Dr. Wiley's office and contemporaneous notes of what the respondent said at the time that she said it, as depicted in those records.
You'll help me if I misremember, but was there also some evidence that of respondent's intention to try to have Dr. Wiley change a note in the medical file? Or?
There was, and there were statements to that effect, and Judge Dwyer didn't really resolve that question because what Judge Dwyer said was that the respondent was attempting to gain access to the doctor and didn't take the next step as to the purpose by which she was attempting to gain access. Both the testimony of the medical assistant as well as the documents, the telephone log notes, both reflect that she was calling the doctor, she needed to talk to the doctor. It was an immediate emergency because she wanted the doctor to change the medical notes. The respondent's testimony was not that she wanted the doctor to change the notes, if my recollection serves, but that it was that she needed to educate the doctor as to the extent of Ms. Duran's illnesses and her suffering. The background piece of this is that this was 1 week before trial was set to begin in the Circuit Court for Anne Arundel County. I think it was July 28th, the trial was set to begin. These telephone calls occurred on July 21st and July 22nd. The client, Ms. Duran, had been in the hospital for which Dr. Wiley was doing rounds or had treated her or had seen her, and had stated, and this is through the respondent's testimony at trial where it's in the record, had stated that Ms. Duran was not in fact ill and had ordered a psychiatric evaluation. And so it makes sense that the respondent was calling Dr. Wiley to reinforce that she believed her client was in fact ill and that it was a result of the toxic mold that she had experienced and that she did not need a psychiatric evaluation. But Judge Dwyer did not make those sort of second level findings of fact. Nor do I think that they're necessary to sustain the conclusions of law that the respondent violated 4.1a, and similarly that she violated Rule 4.4a. And that's critical because she was attempting to obtain information and access to the doctor where the doctor did not have any sort of release or subpoena from Ms. Maldonado, which would have enabled the doctor to provide her with any information or to share any information with her. The court found that it was a disregard for the requirements of the law and the doctor-patient privilege between Ms. Duran and Dr. Wiley as it exists. The unauthorized practice of law and the respondent's conduct on July 21st and 22nd, 2015, along with the substantial aggravating factors present in this case, compel a conclusion that the respondent should be disbarred. Judge Dwyer correctly found that the respondent engaged a dishonest or selfish motive, that she knew that she was unable to represent Ms. Duran in Maryland, and she manipulated around the barrier by using the client's email address and drafting pleadings pro se, that she engaged in multiple offenses and bad faith obstruction of the disciplinary proceeding. Ms. Maldonado submitted false evidence during her testimony at trial and engaged in other deceptive practices. She has refused to acknowledge the wrongful nature of her conduct. She has substantial experience in the practice of law, and there is a likelihood of repetition based on her refusal to acknowledge the wrongful nature of of her misconduct, and Judge Dwyer noted that the respondent had in fact drafted another complaint for another client to file pro se in a different matter. I would ask this court to disbar the respondent.
May I take you back a half second here? With regard to that aggravating factor that Judge Dwyer found, was the judge relying upon respondent's omission to say, "I'm sorry for what I did," in predicting that she would be likely to repeat this kind of behavior?
Well,
Does that make sense?
there certainly was an absence of saying, "I'm sorry for what I did."
I understand, but does silence on that subject, as opposed to an overt expression of remorse, does silence weigh against a respondent in a given case? Does it depend upon the particular facts of that case?
So there's remorse is a mitigating factor. So if the attorney wants to prove remorse, they have to put on the affirmative evidence.
Understood.
By a preponderance. And then lack of remorse is an aggravating factor, which petitioner has to prove by clear and convincing evidence. And so the absence of any acknowledgement of remorse, combined, I think, with the conduct that lasted throughout the proceedings in this case, where it wasn't only an absence of saying I'm sorry or refusing to admit that anything that she had done was inconsistent with the rules of professional conduct, the totality of her behavior through the disciplinary proceeding, the obstructionist behavior, her testimony at trial, and I think notably her testimony seemingly without an acknowledgement that anything is wrong, that she had done this before in a different Maryland matter. So I think it's like the circumstantial evidence provides for the absence of remorse. It's not saying I'm not remorseful, but it's all the factors combined in behavior, both in the underlying matter, but as well as during Bar Counsel's investigation and the prosecution of the case in the circuit court.
How does an attorney both defend against charges and express remorse in the same proceeding?
Well, I think in certain cases, and critical for this case, is the respondent has never denied that she called the doctor's office and said she was a doctor. She has never denied that she drafted and filed these pleadings, and it's a complete absence of a recognition that these things are contrary to the Maryland rules that demonstrate a lack of remorse. You could say...
Again, though, and this is a broad concern that I have. I've never understood how an attorney can exercise his or her right to defend against charges without being accused of lacking in remorse.
I don't know if I know how to answer that question. I mean, the way the disciplinary system is established is there is one hearing, and at that hearing, petitioner proves the averments of the petition, and the respondent has the burden of presenting any evidence in remorse. It's not bifurcated as in a liability in damages or liability in sentencing. So that's your opportunity to present evidence of remorse, and you don't have to.
I wasn't guilty, but I'm sorry.
Well, you can. I don't know. I mean that's the way it is, and I mean this court has found that people are remorseful, and I think when you have the evidence that is so overwhelming of conduct that is not disputed, and a failure to acknowledge and appreciate that it is contrary to the rules of professional conduct, that is the absence of remorse, because it's not a denial that the conduct occurred; it's a refusal to acknowledge what the conduct means. And so I would ask this court to disbar the respondent, not just for the protection of the public in Maryland, but to send a message to members of not only the Maryland bar, but members of the bar of other jurisdictions for attorneys when they come into Maryland, what conduct will and will not be accepted. The only other thing I'd like to note is in reviewing the transcript from the hearing in this case, Ms. Duran's name, she testified at the hearing. There's a typographical error that the transcription refers to her as Ms. Stern throughout, but it is in fact the client, Gladys Stern, that testified. If There are no further questions. Thank you.
All right, thank you, Ms. Lawless, Mr. Ms. Maldonado, and Ms. Rice. There you go.
12
Thank you.
minutes? Okay, thank you. I would like to say everything respectfully that the petitioner said is incorrect, and there's clear legal error here. If you look at my litigation record in Maryland, there's 2 other cases, and Janine Burke was my co-counsel, and we entered and filed a complaint at the same time, and that was for the little girl that we saved, that wouldn't have been saved. So there's clear legal error here, because it's not like, oh, I'm not learning my lesson, whatever. No, what the petitioner is failing to recognize here is that this was heinous foul play by the defense firm. James Liskow that filed this grievance, and the DeCaro Duran firm. DeCaro was on the Grievance Commission for 10 years. That's what they were doing. They were trying to shut this down, and they used this as a tactic by preponderance of the evidence. And I cite in my filings where James Liskow lied under oath. He said, oh, I didn't threaten Chris Nace. I didn't use this as a tactic. Yes, he did. And the evidence is by preponderance of the evidence. So I would like to say respectfully that if you look at the cases that I've litigated, Janine Burke was the co-counsel, and if you see the progression, we entered at the same time. And I'd like to say that I did have a Maryland legal team, and Chris Nace abandoned this client. James Liskow threatened him. Chris Nace abandoned the client, and he lied in the motion to withdraw on October 2nd that he sent me certified mail and email. He did not. And Judge Peter Krauser on October 21 granted the withdrawal without making sure that it was factual, that the evidence was factual, that Chris Nace did get money. So here we are. What this is about, I'm not a bad person. As I told you earlier in my opening, I said I won't ever be in this situation again. And when I met with the peer review panel, they wanted to dismiss. And they even said, your heart is really strong. You have a strong heart, and I'd like to say a strong, and my God-given intellect, I use them in unison. So this was to try to save a lady that was disabled by James Liskow. And I did have a team. In fact, I had 2 teams. And here's the most critical issue of all, I will say, as a toxic tort attorney specializing in this field, that what the petitioner and all these parties don't realize is that James Liskow, and this to me is the most critical of all, they sabotaged the toxic mold tester. The guy, Jeff Pace, that went into the townhome and got the swabs. And I spoke with the PhD CEO of that company that writes those mold reports, and they sabotaged him because they slandered me to him, like they were doing to the Grievance, and in contradiction to the evidence. And also Chris Nace, you'll see in the evidence I gave you, there's an email I said, Chris, you have to subpoena this witness, the guy that got the mold samples. And he didn't. So my hands were tied. My hands were tied by these lawyers. And I'd like to say that that's why in the appellate process, Janine Burke and I couldn't go in. So we have a human being who was disabled by preponderance of the evidence by James Liskow's clients. And then I still didn't give up. I'm a fighter. I didn't give up. I found another lawyer, even when the Grievance Commission was throwing questions at me all during this appeal, which I think they should have put it on hold. Let me try to save the lady with a Maryland counsel. Let me focus, and then I'll be glad to address any questions you have. So I still fought for this lady and took it up to the United States Supreme Court with Melinda Maldonado, another Maryland attorney. So I still tried, and I put an application to the Supreme Court, and it's been on hold because of this. So this defense law firm on the opposing side interfered from the beginning to the end, and I'll even add the petitioner as well. So I won't ever be in this situation again. I saw a human being, and I saw that this mold tester was sabotaged. Janine Burke, she's been my co-counsel on the 2 cases after this, and I would say substantially. If we, Janine Burke and I, had done this case, we would have won for Gladys Duren. And she would still be singing at last better than Etta James. And I just want to show a picture of her because I think it's rotten that the defense firm is not taking accountability. Instead, I've been on trial. The companies they represent should be on trial. And so, and I'd also like in closing to talk about the ghostwriting a little bit more, given that fact about the mole tester. Under the Maryland Code, Rule 1-311, every pleading and paper of a party who is not represented by an attorney shall be signed by the party. Ms. Duren signed everything. And when there was an electronic file, she was in the hospital fighting for her life. She's been in 100 times. In the Federal Rules of Civil Procedure, Rule 11 also says the same thing. Every pleading and paper of a party who is not represented by an attorney shall be signed by the party. And I'll say, Gladys Duren, she had attorneys. She had Maryland's attorneys. She had 2 teams. And in between, it's because there wasn't a mole tester. They sabotaged him. So, and I'll also say the petitioner during this process, and that was a wonderful question, about when you're fielding attacks and showing remorse and all that, what I'd like to say is, not only is this a human being, but if you recall Officer Sully, the pilot that landed the plane on the Hudson Bay, I couldn't believe it when I saw Tom Hanks in that movie. I was like, wow, he saved the whole plane, and he still has to go through a hearing to defend himself. My goodness. And I'd like to say, with all due respect, I was Officer Sully, but I was fielding the questions. I was going through the hearing while I was trying to land the plane. And if Officer Sully had been going through the hearing when he was trying to land the plane on the Hudson, he would have crashed. And I think that this case should set a precedent that when an opposing firm is filing these grievances, it raises a huge red flag. And I'd like to just say that I hope and pray that you guys, that your honors look at this, that this was a firm doing this, and that my co-counsel abandoned Gladys Duren, and I never did. And I won't ever abandon her. And I just want to say that's the kind of attorney I am, and this is why I keep getting these awards. And so I was in a pickle because my lawyers didn't put my exhibits in, and that's tough. But I just want to reiterate that over these 3 years, I've been treated horribly. And the petitioner, they broke the law. They trespassed at my office. When I flew back from my mother's memorial service on June 26th of 2017, this was our second memorial service. Her birthday's on June 20th. When I flew back that night and I went to my local home and office, an agent of the petitioner trespassed through the door, and they proceeded to go up to the 21st floor, and they were banging on my door for 20 minutes, and I called the police, the Arlington County Police, and I put that in as an exhibit for you. And they even hung a black shirt on my door, as I've mentioned before, for 3 weeks that summer. They were threatening me. They were bullying me. It almost felt like mafia tactics. And I'd like to say one of my witnesses, Liz Gregowitz, said, "Watch your car." And my family said that too, like the Godfather, watch your car.
Ms. Maldonado, when did you first become aware that a complaint had been filed against you in this matter?
Thank you for the question, Your Honor. The petitioner had a process server pose as a potential client on June 14th, 2017. And he said that his mother was admitted to the hospital that day. That's when there were shootings at the Alexandria softball field against the GOP party. They had the shootings. That was the same day. And they went to the George Washington Hospital. So this...
That's when the commission attempted to serve you with the petition for disciplinary action. when did you become aware that there had been a complaint filed before the petition?
Yes, Your Honor. And I'd like to say, to correct the record, that I respectfully answered everything and in great detail on, this was July 2016, and it's an exhibit. I answered everything and in great detail. And I sounded the alarm, the red alarm. Look at what the defense firm is doing. Look at what they're doing. Doom. I put everything. Experts lying, they're not answering discovery, they refused mediation, they're lying about me. And I'd like to say that that was when I did, and I answered respectfully for 3 years. And on June 14, 2017, that's when the process server lied, and I just felt like an ick factor, like this is a dishonest group. I just felt so violated, and it's so in contradiction to who I am, everything that's been said about me. And what this is, it's about Gladys Duren. It's not even about me, and they flipped it. So I just want to say, I wanted to address that when they were giving me these questions, I met with a peer review panel, October 28, 2016. I gave them a very detailed answer, October 18, and they wanted to drop this. They wanted to dismiss everything. So I've endured 2 more years. And I'd like to say in closing that the exhibits will dispute everything that the petitioner's saying and what Judge Dwyer was saying, because my lawyers didn't put the exhibits in. And I'd like to say in closing, tomorrow's election day, Doris Kearns Goodwin just recently wrote Leadership in Turbulent Times, and she said the number one trait is empathy. The number one trait's empathy. And I would say that that's what we should all strive for. And I saw in the judge below, Judge Dwyer, when Stephen Markey was on the stand.
You can wrap it up very
Okay,
quickly.
I'll wrap it up real quick. Stephen Markey said clients come in, toxic mold exposed clients come in, and they're crying because he's not helping them because chest in case. And Judge Dwyer grunted, move on. So thank you.
All right, thank you.
Okay.
Ms. Maldonado, and you, Ms. Lawless.